Welcome to a courtroom where patience is thin, second chances are thinner, and Judge Boyd does not hand out mercy like candy. Watch closely. This case is about choices, consequences, and a probation clock that has officially run out. Would you still expect leniency if you had already burned through every warning?
So nice to have Judge Boyd back. You were missed. Isn't it great hearing?
All right, the court is calling to...
Anyway, make sure to tell us if this guy deserves what was coming to him by commenting down below. Like and subscribe, set your notifications to all. Let's roll, nerds.
State versus Jonathan Vargas. Can I have parties approach and announce for the record?
Attorney for the state of Texas.
Good morning.
John Foley, Your Honor, on behalf of Mr. Vargas.
And are you Mr. Vargas?
Yes, Your Honor.
All right, are you all ready to proceed?
They're ready to play.
Okay, let me pull up the document. All right, what are the results on the UA?
Came back positive for marijuana.
A failed UA test is never just paperwork. In probation court, it is a loud alarm bell. It signals relapse, risk, and resistance to court orders. This is the moment when judges start weighing safety against sympathy. Should caretaking responsibilities excuse repeated violations?
Judge, we'd ask a court to either continue Mr. Vargas on deferred or to revoke him and give him regular probation with a jail sanction if necessary. Mr. Vargas is the sole caretaker for his child. He's a stay-at-home dad. He has a business where he mows lawns, but he does that.
I mean, it's like maybe he shouldn't be taking care of his child if he's using. I don't understand why you're coming in and testing positive with the court. And according to this, you've already been sentenced to safety. So who's with your child now? All right, so we have a mom.
Here is the emotional pivot of the entire hearing. The defendant leans on family responsibility, but the court pivots to public safety. One child. One parent. One pattern of drug use. Where should the line be drawn?
I don't know how else to help you.
I had stopped smoking prior to me turning myself in, and I know I was told that marijuana stays in your system for a while.
But no, this is not your first motion to revoke.
Correct.
And it's always a motion to revoke for use. And I just don't know what else. I don't know if there's anything else available for you.
Is there any way I could be on probation and get drug tested every week?
No, because then what's happening is
Weekly testing sounds reasonable on paper, but to a judge it signals a deeper truth. Probation is not babysitting. It is trust. And once that trust collapses, the courtroom temperature drops fast.
19, and there just hasn't been any improvement. I just don't think probation, there's nothing else I can do. What I can tell you is you will receive credit for completion of safety. You'll get credit for that. So
Judge,
yes.
if I may, I think there has been some improvement though, in that he has been voluntarily, I think he's genuinely trying to better himself. That is, he has voluntarily been seeking treatment. He's been going to that treatment. He's successful at that treatment for his heroin addiction. He did slip when he knew he was going to be turning himself in. He I think, was nervous about it, and he smoked marijuana, but he didn't go back. He didn't, regress to go back to the heroin. And I do think he's showing some improvement in that way, Judge.
All right. This is what the court is going to do.
This is the hammer drop. Deferred adjudication is officially revoked. 2 years in prison is not just a sentence. It is the court saying rehabilitation efforts have crossed into final accountability territory. Do you think the judge waited too long, or was this the only ending left?
And counsel, if you get with the clerks, they'll be able to tell you how much time that is.
I'm sorry, Judge.
If you talk to the clerks, they'll be able to tell you how much time he's receiving for credit for the inpatient treatment.
Okay.
There's an affirmative finding of family violence. There's to be no contact with the complainant. And I'll ask for the therapeutic community.
And Judge, did you say also credit for time served or just for the?
Yes.
Oh, okay, good, thank you.
I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and sign it?
Sure.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you're on deferred adjudication. Because this is a felony conviction and because there's an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over that, you'll need to speak to an attorney. Do you understand?
Yes, sir.
All right, I can't force them to place you in the therapeutic community. You'll still have to request it, but they'll see where I've requested it. That program is designed to help you with any drug issues you may have.
The courtroom shifts tone here, but the consequences do not soften. A felony conviction, family violence findings, and weapons bans follow this defendant far beyond prison walls. This is what long-term impact looks like. One mistake does not end lives, but repeated choices rewrite them.